Our second panel, Creating Lawyers, How'd You Do That, will be facilitated by Randolph Stone. Randolph is a clinical professor in the Criminal Juvenile Justice Project, former director of the Mandel Legal Aid Clinic, and former public defender of Cook County. Randolph?
Great. Well, we've got an exciting panel here, and just briefly, to my left is Jonathan Baum, who is a pro bono coordinator at one of the large law firms here in Chicago, former clinical teacher as well. Next to Jonathan is Stephen Krieger, also a former clinical teacher here in the clinic, now in New York, and is going to be our primary presenter here today, and I'll talk more about that. And pardon me? Is that good? Everybody happy? All right, good. The far end of the table is Emily Buss, tenured professor here at the law school, specializing in family law and teaching a variety of other subjects. To begin the panel, how'd you do that? Creating professionals as part of the clinical education process. Steph is going to present some empirical research that he has done to try to begin to analyze the process. And why don't we start off with Steph, and then we'll have responses from each of our two panelists, and we'll try to save room for questions and comments from the audience.
Our mentor, Gary Palm, from day one that I was teaching in the clinic, taught me three things. And I think he probably taught most of us these three things. One, that when you face a case that you have to explore it with rigorous analysis. Second, that you would pay attention to details. Every single little tiny detail in a case could be important to what that case will be for your client. And also, though, to take a very skeptical stance when looking at both the client's story and the story of the opponent. Unfortunately, that was not entirely the approach of the Carnegie Report. Frequently, the report presents broad generalizations about legal education with very little citation to empirical research supporting the claims, and is based in large part on anecdotal evidence. Survey visits, not a very rigorous methodology, but just visits to different law schools to see what was going on in legal education. Let's just take a look, for example, at some of the report's findings. The report claims, for example, that clinical training is the law school's primary means of teaching students how to connect the abstract thinking formed by legal categories and procedures with fuller human context. In another part of the report, it states that from its informal survey of clinical programs, that the responsibility of clients and accountability for one's own actions are at the center of the clinical experience. And then at another point in the report, it contends, context-based education is the most effective setting in which to develop professional skills and knowledge. Well, everyone in this room, I'm sure, would applaud these assertions. None of these claims are supported by strong empirical evidence. Besides these claims of the benefits of clinical education, the report also fails to analyze closely what precisely makes clinical education works. Several times in discussing clinical education, there are statements such as this one. Taught well, it is through this experience, the experience of clinical education, of lived responsibility, that the student comes to grasp that legal work is meaningful in the ethical as well as the cognitive sense. That sure sounds nice, but the report never explicitly describes exactly what taught well means. It simply fails to detail its assessment of what precisely constitutes a good clinical education compared to a mediocre, a not taught well clinical program. Finally, the report's discussion of cognition is based in large part on one theory in the cognitive science literature on clinical practice, what experts in the field call the situated model of clinical cognition, and it ignores other competing theories. To just lay it out, making bread, playing soccer is not the same thing as the expertise of practicing law or some other profession. It makes the assertion that formal knowledge is not the source of expert practice. The reverse is true. Expert practice is the source of formal knowledge of practice. That comment, the reverse is true. Expert practice is the source of formal knowledge of practice, is a statement that is subject to debate in the cognitive science literature. This is not to say that the report is wrong in its theoretical base about apprenticeship education. It is only to caution against an unreflective acceptance of the report's theoretical assertions. Unfortunately, the Carnegie Report, like much of the literature on the benefits of clinical education, reads like nothing more than an extended opinion piece. For the most part, it doesn't reflect the kind of rigorous thinking, the kind of attention to detail, the kind of skepticism that was demanded of us by Geary, or which those of us who teach in clinics aspire to require of our students. Precisely because of this deficiency in the literature on clinical education, I have attempted to begin some empirical research on the subject. For the past 5 years, I've been working with Professor Vimla Patel and her colleagues on developing research projects on legal education and the profession. Dr. Patel, for the past 2.5 decades, has been conducting empirical research on medical education at McGill, Columbia, and presently at Arizona State University. I am not saying here that legal thinking and medical thinking are identical. What I'm saying is that some of the methodological methods that Professor Patel uses can be helpful for us in evaluating what the effects are of clinical education. One of our areas of study has been the comparison of traditional medical curricula with problem-based learning, precisely like the issue that we are discussing today. In a number of her writings, she has cautioned against what in the medical education field is the bandwagon acceptance of problem-based learning in medical education. As she has written in regard to problem-based learning, as is often the case, innovations in practice outstrip theoretical justifications or empirical research demonstrating the validity of an approach. Vimla and her colleagues have worked with me in replicating some of the studies that she has done on medical education in the domain of legal education. Last year, I published the findings of my first empirical study in the Journal of Legal Education, and in that study I tried to analyze the development of expertise from year 1 to year 3 in law school education. As a follow-up to this study, in consultation with Professor Patel and her colleagues, I have conducted a study on the effect of clinical education on legal reasoning. The study was conducted here at the University of Chicago in late April 2006. It is that subject which I'm going to discuss today. In this study, we focus on 3 groups of subjects. 2Ls who are never enrolled in a clinical program at the end of their second year, 3Ls at the end of the second year without any clinical education, and 3Ls at the end of their 3rd year who had participated in the Mandel Legal Aid Clinic. Each group contained 10 subjects who volunteered for the study. While I'm sure I can see the bubbles over all your heads saying, well, that sample seems very small, the methodology we followed is consistent with those in other qualitative studies. Hopefully, it's going to be replicated by other studies, and the size of the sample is similar to those that have been used in the medical field and other professional studies of professional education. For the study, we based the stimulus material, the problem that the subjects had to tackle, on the facts from an Illinois appellate decision concerning a homeowner's insurance policy and the homeowner's dispute with State Farm, who refused to pay a claim. In that case, the company denied a claim for water leakage in the client's home. The legal issue was whether the client reasonably relied on a State Farm brochure for an all-risk homeowner's insurance policy. The subjects were each given this stimulus material for 5 minutes, and then one of my research assistants conducted what's called a think-aloud interview with them, trying to get them to say everything as soon as it came into their head as they were reading and as they were examining the problem. Each interview took approximately 30 minutes. We asked the students, after we took the problem away from them, to recite the facts of the case. We then asked them for their assessment of the case and the basis for their assessment. We asked them what they would tell the client at this point. And finally, the research assistants asked the subjects what steps they planned to take in the case. We transcribed all of these interviews. And then we coded the data, and the coding was totally anonymous. We had no idea which subject was which when we were coding, using a technique developed by Dr. Patel and her colleagues called propositional analysis. On each script, we identified every single discrete proposition that the subject stated. This could be, in one sentence, could be 3 or 4 different propositions. We then developed a coding key to guide our coding of the propositions. We identified each proposition for a fact identified, for the relevancy of each fact identified, and the way we assessed the relevancy was based on the facts that were provided in the court decision. Identification of legal rules. Again, we based this upon the rules stated in the decision. We coded for the subject's drawing of inferences from the facts in the problem, the identification of client interests, and the identification of next steps that the subject would take on behalf of the client. The 2 research assistants and I scored the transcripts and then met to reconcile the differences. After scoring the interviews for each client, we are now analyzing the data, and that's what I want to present to you today. And in the folder that you got when you came here, there are handouts which include a review of the findings. So if you turn to page 1 of the handout, this is the recitation of facts by the 3 different groups. What we found is that 3L subjects without clinic identified the highest average number of total facts, followed by 2L subjects without clinic, followed by 3L subjects without clinic. In terms of relevancy of the total facts recited, 3L subjects with clinic recited the highest percentage of relevant facts, followed by 2L subjects without clinic, followed by 3L subjects without clinic. The 3Ls without clinic identified, of the facts they identified the highest percentage of relevant facts. The preliminary conclusions, in terms of the relevancy of the fact, the least percentage of relevant facts were by those students who had not taken a clinic. The preliminary conclusions that we drew from these findings is that while 3L subjects without clinic recited more facts on average than 3Ls with clinic, more of the facts identified by those subjects were not relevant to the problem. More of the facts identified by the 3Ls without clinic were not relevant to the problem. Perhaps this is what Patel calls the intermediate effect. As novices gain more expertise, they begin to focus on all the facts presented in a case, both relevant and irrelevant. They just look at as many facts as they possibly can. It's kind of like the med student who sees every single ailment as some disease as they go through the medical training. And only as they become expert can a professional distinguish between those that are relevant and those that are not. The 3 L's with clinic from this study were better able to filter out the irrelevant facts and focus on those that were relevant, even though the problem did not directly deal with any of the subject matter areas in the clinic. Perhaps the training in the clinic has encouraged a process of limiting the facts to be considered, that you don't look at a whole slew of facts, but you try to filter those down. Now let's look at page 2. This is identification of substantive rules. Our findings were that 3L subjects without clinic identified on average the highest number of rules, followed by 3L subjects with clinic, followed by 2Ls without clinic. In regard to the relevancy of the rules identified, 3Ls without clinic on average identified the most relevant rules, followed by 3Ls with clinic, followed by 2Ls without clinic. As to the identification of irrelevant rules, 3Ls without clinic, like with facts, again led the pack, this time followed by 2Ls with the 3Ls with clinic in the rear. In terms of the percentage of relevant facts identified, 73.86% of the rules identified by 3Ls with clinic were relevant, 67.05% of the rules identified by 3Ls without clinic were relevant, and 61.19% of the 2Ls without clinic were relevant. Here are some preliminary conclusions that we drew from page 2. Once students reach 3rd year, regardless of whether or not they enroll in a clinic, they are better able to identify rules, and the rules they identify are on average more relevant. Actually, 3rd year does have some effect on legal reasoning, something that we all sometimes question. Second, the 3Ls without clinic are more likely to explicitly recite rules, both relevant and irrelevant rules, than those who are enrolled in clinic. Perhaps this is another indication of the intermediate effect, that, oh boy, you know, here's this problem, what are the different rules we have? 3Ls without clinic were more likely, though, to identify relevant rules than their clinic counterparts, although the differences were not substantial. Several reasons may exist why 3Ls without clinic were able to identify the highest percentage of relevant rules. One is the clinic students, through their casework, spend less time explicitly considering legal rules than those who have not enrolled in a clinic. They may just use the rules in practice, but not explicitly articulate them. Second, clinic students may be less concerned with legal theories than their non-clinic counterparts. They may, in fact, not be applying what they've learned in the doctrinal classes and see a demarcation between clinic and the rest of law school. And a third hypothesis is that to a lesser extent than 3Ls with clinic, 3Ls without clinic considered the problem like a law school exam. One of the problems with these studies is that students are so tested that they look at a problem like this, like a law school exam. And perhaps those without clinic thought, oh, this is another exam where the more issues that I spot, the better. Page 3, drawing of inferences. It's pretty clear. 3Ls without clinic drew on an average the most inferences, followed by 3Ls with clinic, followed close behind by 2Ls without clinic. We tried to code for the reasonableness of the inferences, but the numbers were so small that we could not come to any conclusions, even preliminary conclusions, about the reasonableness of the different inferences that were drawn. Here are our preliminary conclusions as to inferences. 3Ls without clinic were more prone to draw inferences from the facts that were provided in the problem than those with clinic. it appears that clinic students are more likely to just stick to the facts of the case that is given to them. Now, this could be a sign of cautiousness that we teach them, don't assume anything. It also could be a sign of less creativity, that what we do in clinic is to not encourage the possible drawing of inferences, of hypotheses. An interesting point here is, as we're going to see when we get to the next steps graph, is that 3Ls without clinic were more interested than 3Ls with clinic in investigating facts for a case. It seems to be contrary to our intuition and the suggestion in the Carnegie Report that clinics actually encourage fact investigation. We did not find this here. Next page, page 4. The identification of client interests. What we found is that 3Ls with clinic identified on average the highest number of different interests. That was followed by 2Ls without clinic, followed by 3Ls without clinic. The most frequently identified interests were across the board for all three groups, that State Farm owed the client, that there were damages that were due, litigation costs. But as to litigation costs, there was an intriguing finding that 1/2 of the 3Ls with clinic identified litigation costs as an interest the client would have to consider. 2/5 of the 2Ls without clinic identified that interest, and only 1/5 of the 3Ls without clinic identified litigation costs as an interest. The range of options was much greater for subjects with clinic than those without clinic. 9 interests for 3Ls with clinic, 6 for 2Ls without clinic, and only 4 for 3Ls without clinic. The 3L subjects with clinic were the only subjects who identified 2 particular interests: relief for similarly situated customers. That's a good Mandel legal aid clinic. Let's look at reform litigation. But then the other interest was quick resolution of the claim. I'm not so sure if that was what was taught at Mandel or if that's a reaction to what is taught at Mandel. The 3Ls without clinic were the only subjects who did not identify these interests: revenge, pride, the need for changes in State Farm, practices and policies, the assessment of what the case is worth. And no subject in any of the 3 groups identified, and to me one of these is very surprising, apology or peace of mind. The ones with clinic didn't identify those 2 interests. Here are our preliminary conclusions. Subjects who participated in the clinic were better on average than those without clinic in identifying client interests. In fact, comparing the 3Ls without clinic and the 2Ls without clinic, the 2Ls without clinic identified on average more client interests than the 3Ls without clinic. Comparing these findings with those on rule identification, it appears that 3Ls without clinic focused more on issue spotting than problem solving. It was the law school exam approach rather than something beyond that. And perhaps at this point in law school, the end of law school, all they want to do is just give a legal answer and get out of it. The other interesting conclusion, preliminary conclusion, is that litigation costs as an interest were identified more on average by the 3Ls with clinic. Even though clinic clients don't pay fees, that what the clinic subjects appeared to be more sensitive to was an issue of actual practice that is faced day in and day out than the 3Ls who had never taken clinic. Finally, and if you look on page 5, I think you will see a very good example, and this is actually pretty much a standard. It's not like we took the stark extremes, but the standard differences of the statements between the 3 different groups as to client interests. If you turn to page 6, we're into the world of next steps. The subjects were asked what steps they would take next in the case. The findings were that on average, 3L subjects with clinic identified the largest number of next steps, followed by 2Ls without clinic, and again, in the rear, 3Ls without clinic. The most frequently identified next steps, 3Ls with clinic, to me this is very intriguing. 3Ls with clinic, on average, identified most general legal research and to try to find some analogous cases. The 3Ls without clinic identified fact investigation and analogous cases. The 2Ls without clinic, negotiation, counseling, obtaining additional documents. The 3Ls with clinic were the only subjects to identify these next steps that could be considered by the client and the lawyer: mediation, sympathize with the attorney, try to deal with make sure the client knows about the attorney-client privilege, and then a good Mandel response, lobby for changes in insurance regulations. The 3Ls without clinic were the only subjects who identified these areas of fact investigation, talked to attorneys who handled similar cases, talked to the secretary for the State Farm agent who sold the policy, find out what kind of type of neighborhood they're in, that the client is living in, and then contact the Better Business Bureau. Here are some preliminary conclusions as to next steps. The clinic apparently trained students to consider more extensively the actual process of developing a strategy to resolve conflict. Even though 3Ls with clinic identified less rules than 3Ls without clinic, they focused on legal research as the next step. It's odd. Identification of rules weren't that important when looking at the interview, the problem, but after the interview, they needed to do some legal research. Perhaps this is the students in clinic feeling that they have to handle every case as a difficult federal case. As with client interests, 3Ls without clinic identified the least number of next steps, even lower than 2Ls without clinic. Again, perhaps these subjects viewed the problem as a law school exam. Obviously, this is only a small study. The sample size is very small. However, the findings are consistent with a number of the findings in medical education research by Patel. This study needs to be replicated. It should be replicated at other schools. It should be replicated perhaps with students that are 1 year out of law school to compare clinical education with what it's like 1 year out. And it should be expanded upon to explore some of the issues that are raised by these findings. Here's a summary of some of the preliminary conclusions that struck me as most important. 3L subjects with clinic outpaced their counterparts, the 3Ls without clinic, in identifying client interests and next steps to take in a case. It appears that just a 1-year clinical experience trained students to consider more in depth the needs of the client and to engage in strategic decision making. Without clinic 3Ls, the 3Ls seem to be focused on the traditional law school task of identifying issues. The second stark finding to me is that 3Ls without clinic identified more rules than their clinic counterparts. Perhaps it's another example of the 3Ls without clinic looking at issue spotting is so important. It also might mean that students who have had experience in clinic are less likely to explicitly state rules, and it could also suggest that clinic students are more likely to exclude legal reasoning from their analysis in the case and to focus more on interests and next steps than on, in fact, legal doctrine. Finally, 3Ls without clinic appeared to focus more on the facts of the case. That, I think, is something that needs to be explored. And now, they did look at both the relevant and the irrelevant facts, but they looked at facts and considered facts more than the 3Ls with clinic. They drew more inferences. They identified fact investigation as one of the next steps to take in the case. Perhaps the 3L subjects with clinical experience were more concerned about litigation costs, getting the case over with, but they were less concerned with fact investigation. As you can see, this study raises many more questions than it answers. Here are some areas for further exploration. The effect of clinical education at other schools, other non-elite law schools. The effect of simulation courses or first-year lawyering courses, whether or not that has much effect on legal reasoning and the response to a client. The effect of one-semester clinics compared to full-year clinics. The effect of, does practice basically have the same effect as clinics, so the amount of money that is spent on clinic may be up to question. That in fact, the profession may, in the first year, on average, do as good a job as clinical education. But with hard empirical evidence, we can start to explore some of the issues raised by the Carnegie Report rather than simply rely on survey data by the enthusiasts. At the end of the Carnegie Report, the authors note that most medical schools have an Office of Medical Education at the institution, and the report encourages law schools to follow suit. I join in this call and invite others to start engaging in empirical research of legal education, and especially clinical education, rather than relying solely on survey data and anecdotal evidence of how good students feel once they have experienced a clinical program. Only in this way do I believe that we can begin to determine how best we can create high-quality attorneys. Thank you.
Well, I have to begin by saying how depressed I am by the results of Steph's research. And I'm so glad that I prepared my remarks lauding all the wonderful things that clinical education does before I had the benefit of Steph's research. You know, as I've been contemplating the role that clinical legal education can or should play in shaping the values of lawyers, my mind has turned back to a conversation that I had shortly before I began law school here in 1979. At that time, I was working for then Congressman Abner Mikva in Washington, and my uncle, who is a 1953 graduate of the law school, came to visit me. And he asked me, you know, do you think you're ready to go to law school? And I said, well, I think so, but I do have one lingering concern. I'm afraid that if I go to law school, I might turn into a lawyer. And he knew exactly what I meant. He knew all of the political causes that I had been involved in civil rights and the environment and so forth. and he said, well, you know, it's true. Lawyers make very poor revolutionaries because they never believe anything with total conviction. There are a number of ways in which clinical education contributes to the shaping of the values of lawyers, and I will highlight a few of them, even if they're contradicted by the research. But if clinical education, that is actually applying one's legal skills on behalf of the poor and the powerless, does nothing else, I think it acts as a counterbalance to the mentality that my uncle was describing. So much of legal education, of learning to think like a lawyer, is about the notion that the true professional is essentially indifferent to the justness of his or her client's cause. Our job, we are told, indeed our pride, is to be able to argue either side of any case. We are constantly admonished about the strict division between advocacy, our job, and deciding the correct outcome, which is the exclusive province of judges. But clinical education, at least as I experienced here at this law school, tells the law student that there is a place for conviction in the practice of law. You do not have to be neutral about poverty or racial discrimination or other forms of injustice to be a good lawyer. Of course, clinical education also teaches that simply believing you are on the side of the angels is not sufficient. Clinical education teaches specific skills you need in order to be effective on the side of the angels. Conveniently, given that most law school graduates will not confine their legal practice to the angelic side, these are the same skills lawyers need in order to advocate effectively on behalf of any client. We need clinical education because, at least from my vantage point of 25 years in practice, seeing numerous waves of young lawyers emerge from our law schools, these skills are also those that non-clinical legal education is most deficient in imparting. Let me just enumerate 4 of those skills. The first is empathy. Clinic teaches you how to represent an actual live human being with all the fears, flaws, and foibles that accompany being human. The second skill is responsibility. Clinic is usually a law student's first opportunity to actually assume responsibility for the outcome of a legal dispute. Someone's welfare, or even perhaps their liberty, is actually in your hands. Third skill is advocacy. Clinic, along with some other opportunities in law school, is a place where future lawyers learn to argue persuasively, brandishing passion and a firm command of the facts, as well as well-researched law. Finally, clinic students learn, often it is my experience, contrary to the research, alone among their law school classmates, to ferret out facts. Fact investigation is a critical aspect of effective lawyering, but this skill is not learned through academic exercises in which the pertinent facts are assumed. As I work with new lawyers, I find that these 4 skills, empathy, responsibility, advocacy, and fact investigation, are what they come out of law school most lacking. And I am grateful that there is clinical legal education to give at least some of our future lawyers a head start in acquiring these skills.
Is this working? Great. Hello. It's great to be a part of this. I was very pleased to be asked to participate because I'm a real fan of this clinic, and I was really impressed when I saw the agenda that there's very little back patting happening today, as far as I can tell. And so I would sort of start by saying I give a huge pat on the back for all that the clinic has done, and what I see through students who come to me, sometimes talking about their clinic projects, sometimes talking about whatever I'm classroom teaching, I think clearly influenced by the kind of framing, some of the kinds of qualities just identify that they get out of that part of the education. I think I can bring together the hopeful remarks about all the good things that one gets out of clinical education and some of the more reserved sort of observations of the study. I think you should do a follow-up study. It seems like your study was very inspired by the medical model, where you have to move in, look at make an assessment of a patient quickly, do a lot of sort of discerning and filtering out of facts in a quick way, and then sort of move on to those next steps. And in fact, the study looks kind of like, I think I would have treated it as a law school exam. They got the fact pattern for a short amount of time and were then called on to sort of to brain dump. That's what we sometimes ask for in our exams. I think if there's a value added, and I believe there is, it would be hard to capture in that kind of a study. You would capture it more by something that would be more comprehensive and reflective and might actually require them to interact with a real client, for example, going forward, or actually taking those next steps and then assessing as they move, those sorts of questions. So I applaud very much the effort to try to get at what do we get out of clinical education? What is the value? But I think it's tricky work. And I don't think it lends itself to quick assessment for precisely the reasons, the kinds of things we think that students gain from clinical teaching. And I think more than anything else, and I think to some extent it's wrapped up with your list of 4, is what Mark said in his remarks, is this idea of developing judgment, and particularly judgment in the legal context. As a classroom teacher, I find the most elusive. I do try, but I think that the context of classroom teaching really does not lend itself to teaching judgment, and that really means bringing it all together. It means knowing what to do with your facts, knowing when legal research is where you should be focused and when it's not where you should be focused, assessing all the different kinds of things you might be able to do for a real human being who has come to you as a lawyer. And I think those kinds of qualities, those kinds of skills, I believe, would love to see the empirical research supporting this, but believe that very much that beginning to practice law in a very structured setting, something you get in a clinic, and really I don't think get most places in your first year in practice, is invaluable in those respects. What I'd like to say, Randolph knows, I've asked him about 5 times, what am I supposed to do on this panel? I don't exactly understand the title, but to the extent I do, I'm not sure what my value added is on this panel, but determined to try to be some value added. I thought that I would maybe draw on some comments that have come up in the course of the discussion, both this panel and the previous panel, and press, maybe sort of push on the points that I think are the sensitive points that did not come out. I think for all of the, there was a little bit of a feel of challenge in the various speakers in the first panel. There was, for the most part, agreement, right? There was, for the most part, an endorsement of an idea that there is, that specialization is appropriate, right? Specialization among different sorts of classroom teaching, to be sure, but maybe most distinctly specialization between the classroom teaching and what those values are and what we can impart in that context, and then the specialization, the values of the educational values imparted through clinical teaching. And I think that is a common sentiment, maybe the Carnegie Report sort of presses and sort of asks whether that's really the right way to go, but I think in the end, most would say we all have an awful lot to do, and we can think of subtle ways we can connect more and overlap in our teaching methods. But for the most part, what we would like is for classroom teaching to be done superbly, recognizing the limitations of the learning there, and then that clinical teaching be done superbly, recognizing the limitations of teaching there. But what that doesn't get to is how do we divvy resources between the two? And that seems to me is the big challenge for law schools going forward, and really thinking deeply about how education should be designed. To be sure, both must have some value, I still believe, after your research, and I think even some of your results actually picked up on that. But we have in most law schools, certainly our law school, a big dose, mandatory dose of classroom learning, and a much smaller dose of optional clinical learning, right? That's the structure. There are limitations in course credits, students who can't get in because of waiting lists, right? So there's a real perception, I think, that what the clinical education is one of a number of good options for students expanding beyond classroom teaching. But just that, right? And the big question is the extent to which there should be a commitment that says this is an important part of legal education, and therefore it should be a part of everyone's legal education. That would be one step. Another would be, and it should be this amount of, right? This proportion of a proper legal education. It is heartening to hear that skills of legal analysis, I guess that's what you found, are still developing in the 3rd year, but there is a sense that we have the luxury in law school of a little bit of extra time, right? There are those who advocate just dumping a year of law school, but many others who just think that gives us room to try things and to learn from those experiments. No reason to think we need to be sort of exhausting every last minute of law school with classroom teaching. So maybe my place on this panel is to say, well, wait a second, you represent a faculty who certainly does not seem to be pushing for mandatory clinic for everyone, let alone some larger amount of credit for clinical legal education. So I thought I'd reflect a bit about the barriers in sort of thinking about moving in that direction. One is what has been highlighted already on this panel, which is that we want it to be quality education. We want it to be education that students get a lot out of, and sorting out what that looks like is challenging, I think. More than that, it's hard to bring, this is Randy Picker's words this morning, it's hard to scale, right? It's hard to get a lot bigger in terms of clinical education without losing quality, because it is so labor intensive. It requires a lot of really superb educators with a relatively small number of students to do well. I think that's very clearly the case. So if we really wanted that to occur, we'd have to think awfully hard about how to ensure quality going to scale. I think attempts to give every student a clinical experience, some schools have gone in that direction, sometimes really stumble on that issue, right? So everybody gets something, but it's hard to be paying attention to what they're getting, and there's a huge range in the quality of what they get. Obviously tied to the labor intensiveness in so the necessary small teacher-student ratio is just the issue of money, right? It takes a real commitment to pulling in the dollars to make that kind of a transition. And then sort of the last thing I would put on the list is this issue of sort of the perception within the legal academy of clinical legal education. And I think that ranges a great deal from one institution to the other, but it does suggest that if there are going to be changes that are really sort of changes that one notices in terms of the balance of education in law schools, one thing that has to happen along the way, certainly tied with this issue of quality, certainly tied with the issue of demonstration through empirics, that we're getting something, is getting a buy-in from an institution that is very conservative in this respect and loves what it does very well. It does do it very, I'm speaking for our institution, I think does it very well, but moving beyond that and recognizing that there might be something else very valuable that students are getting less of than ideal will take a lot by way of demonstration that there's something really important gained from the experience. So one of the things that I think the Carnegie Report sort of notes is that to the extent that law schools have changed the balance at all, it's usually done very incrementally, and suggesting that might not be the best way to approach. Sort of, if we're really reflecting about what education should be about, the increments may never really do it. But it seems to me the other side of that is they just may be that may be the necessary price of a hard to test, believed to be high quality but hard to test aspect of education, where the other aspect of education is so firmly embraced by those who run the institutions. There will be law schools that affect the market by doing really dramatically different things, and if they can demonstrate that they're changing the experience of their law students and turning them into different kinds of lawyers, the more that can happen, seems to me, the more in turn that experience can affect the incrementalists, I should say. The other thing I wanted to note, which I think very much is tied to some of Jonathan's remarks, is that what we, again, sort of I was trying to figure out the title, and first I thought maybe it should be how should you do that rather than how do you do that. But the other thing is thinking about creating lawyers. I think in the discussion so far there's an assumption that there is an ideal lawyer, and how well do we do at creating those ideal lawyers? And it seems to me one of the things we ideally would be about in law schools is helping to define what we mean by lawyers. And by this, I don't mean something incredibly radical. I think the discipline has defined itself, the profession has defined itself fairly well, and it fills a niche, it does something quite important. But the idea that one of the things that we could gain through how we teach and through clinical education is a sense of competence among all students, that they could go out and whatever they're doing, maybe they're going to go work in a big firm, maybe they're going to be a solo practitioner, but whatever they're doing, they are in a position to also be giving back or serving those who won't be able to just sort of readily get legal assistance. So the idea, it's partly an inspiration to sort of understand that this issue of justice, it's appropriate for that to inspire your practice, but it's also, I think, a question of lawyers understanding that whatever direction they go, that it is appropriate and possible for them also to be community citizens in a way that really takes advantage of their special skills. I mean, I fear when I see our lawyers, our law students, excuse me, graduating and going off to the big firms, not, oh dear, you know, you've gone to a big firm, what a terrible choice in some kind of abstract sense, but rather what is happening in those big firms, as I perceive it, is more and more a kind of, you know, the hours go up, the pay goes up, the hours go up, the pay goes up, the hours go up. The ability to do the kind of other work in one's community, the pro bono projects, whether within the firm or in some sense outside of the firm, as you know, as professional citizens, seems to me, is evaporating. And I think the more we as law schools can impart that competence and sense that being a lawyer can mean this as well as a way to do a trade and earn an income, the more we are giving that's very important, and they may not be able to get somewhere else to our students. So, some random thoughts, sort of on the agenda topic.
And some very good random thoughts. Sure, why don't we have a couple brief responses from Jonathan and Steph, and then we'll open it up.
I really appreciated Emily's suggestion about the law schools essentially pushing back against the deprofessionalization of what we do. It is quite disturbing, in fact alarming to me, what is happening in the culture, particularly of large law firms, in which it is commonplace now, for example, when a managing partner is addressing the partners on what's going on, to describe what is going on in our industry, which I used to think was a profession. And that is not a merely semantic distinction. And so that to the extent that the law schools can be a counterforce against this pure sort of bottom line mentality of what it is to be a lawyer, and that being a lawyer is just like any other business, that's a very useful purpose that either academic or clinical education in the law schools can perform.
I'd like to respond to Emily's point at the beginning of her presentation concerning comparing the medical school studies with the legal studies, and I think it's the criticism is well taken. I think when we drafted this problem compared to the first problem that we did a few years ago, we tried our best to take it away from the law school exam kind of approach. The questions that we ask, we try to encourage them from the script that we had for the research assistants to get them away from the law school exam approach. But it's there. And I think that in future studies, perhaps using actors, perhaps trying some sort of follow-up to see what they've done, what the subjects can do over a longer period than a half an hour, I think it's a very good idea. But I do have 2 points. One is that what I was trying to test was were the benefits that are touted of what clinical education does to cognition. And I think that there's some, Jonathan and Emily, I certainly don't look at this study as saying close the Mandel Legal Aid Clinic down by any means. I think it's a positive study, but there are questions that are raised in terms of what the effect is on cognitive process. And I think that as in any movement, the clinical movement is prone to get into kind of a cheerleading mentality. And I think that if we really want serious clinical education, we are now a mature enough movement to start to step back and say, well, are these cognitive goals really being met? The third point is that, in fact, I think that at times clients do go to lawyers and want quick responses. I did a presentation at the ALS a few years ago, and somebody came up to me and said, I have just been to a lawyer with a probate issue, and all this lawyer wanted to do was talk about the upsides and the downsides in this case and that case, and I wanted an answer. And I think all of us as clinicians, when we dealt with clients, at times the clients are sick of our going off to the library and doing extensive research. They do want an answer, and they want a quick one. And one size does not fit all for the kind of legal advice that we give, and I think we should be cautious about saying, well, all of our cases can be dealt with in a way that it can take enormous amounts of time and can require extensive research.
Okay, questions, comments?
I agree, and I think one of the issues about recitation of facts is what Patel has written about in her theoretical work and some others in the medical field, is that in fact, expert physicians, when they are handling a diagnosis, do not use the basic science doctrine, basic science knowledge in their description of the problem. They basically, it's unconscious, I think, is not the word. It's a kind of automatic process. Maybe that's what's happening here. Maybe the students in the clinic don't feel the need, not only feel the need, they don't go through the process of articulating rules as much as those without.
First, I want to applaud your efforts to empirically quantify the merits of clinical education, because I think that's an area that's sorely lacking. I guess I have two concerns. The first is the sampling concern. I think, based on what you've described, there's no way that these results you've shown can be statistically significant. Mathematically, it's possible that you just started collecting data in the spring of '06, so it's a little of concern to say that these are differences that are worth discussing at this point, so you have the numbers. Second, even if you had the numbers, to apply the research done on medical clinics to legal clinics is different, because in the medical clinics, medical schools have a culture where you're required to do a clinic. And even if you went to a law school that requires a clinic, there's self-selection. Students have chosen to go to that law school. Obviously at Mandel, when you're talking about clinical students, those are students that have chosen to enroll in the clinic. They may have those differences before they ever get to the clinic, and that might be, if we're seeing a difference, it could be a self-selection issue.
As to your first point, you're absolutely right. I mean, in terms of validity, in terms of reliability, we've gone through the numbers. I could give you the methodology. The differences are sound. But to say that this is a statistically significant study, like a quantitative study would be, you're right, and I am not here as a snake oil salesman to say, these are the findings that you have to take into practice. But I think that, as in any empirical project, we need more of these. We need law schools to be, and law professors to be, and clinical professors to be doing this kind of work. And, find that I'm all wrong. I'm going to post all the transcripts and the codings online. Try to tweak the methodology that we used. Absolutely. I think that these findings are as preliminary as they can get. As to your second point, I'm not exactly sure if I understand it, but what the medical studies do is to, from Patel, is to compare two different kinds of curricula. It's not different kinds of med students at the same school, but it's two different kinds of curricula. Problem-based learning curricula, which, as Carnegie talks about, was first, the pioneer school was a master's in Hamilton, Ontario, and they compare it with traditional schools such as McGill. And so what we are dealing with in some ways is students who from day one are basically learning through practice, and those who take 2 years of basic science and they compare the two. And what's intriguing is that the findings of this very preliminary study are consistent with what happened at McGill. That in fact, students that are trained with a very heavy dose of doctrine, similar to what we have here, in terms of their cognitive process, it appears to be similar to law students at a place like this. It would be intriguing to go to a school like CUNY and to compare that with this.
Sure.
First of all, I wanted to echo some of the notions that Jonathan Long mentioned about empathy, responsibility, and advocacy that are exemplified by students who go to this school. And I wanted to add something that I felt that was a little bit concerning, not just through the conversations that were in this panel, is that the lack of mention about client feedback. Because I think that in a way, what do the clients want? Do the clients want the students who are reciting facts and reciting laws and reciting principles, or do they want a little more empathy, advocacy, and responsibility as is are exemplified by the lawyers? So my question is basically, how do we integrate the voice of the clients when it comes to integrating this aspect that Jonathan Long mentioned?
Well, I think that if your ears are open, that client feedback is almost inevitable. If you don't shut your ears to it, so that so I think that the students who participate in clinics hear from their clients what they've liked and what they haven't liked. But I think you're right that if we can more formally, I guess, integrate that sort of informal feedback into how a clinic conducts itself, that would be a very valuable thing to do.
In that regard, we have a legal services corporation, and they require every one of those body has a service completed for a compromise user. And we learned a lot about too often we were using making everything fit into a form, one model kind of assembly line. Oh, yeah. So too often we were treating everybody sort of the same. We got some feedback on that. I think it's a good thing. Maybe those tell us if we have feedback. Yes, Emily? Emily?
Teachers that are going to private law firms but are very committed to serving people in need. What do you see as some of the ways that we could prepare them to go and be advocates within the law firms to make the law firms more responsive to see best practices there that we could, as clinical teachers, tell our students about and help them advance that?
Well, I do think that, and this kind of goes in waves over time, but certainly now we do see students coming out of law school pushing for pro bono. That's important to them. And that's perhaps the single most important voice in moving law firms on this, because for many law firms, one of the key values of pro bono is as a recruiting device, is what can you say to get the best law students to come to your firm, And one of the things that they care about is pro bono. So one of the things that's very important is, if nothing else, is to tell your students as they're interviewing with law firms to be sure and ask about pro bono. Because the more they ask about it, the more the firms do. And we've had periods of time, I can think of sort of like in the 80s, when students were coming out of law school and nobody was asking about pro bono. And law firms did less of it. So one of the things is simply to encourage them to bring it up, because this is particularly at a law school like this. This is this is their point of maximum leverage in terms of influencing the law firms to do pro bono. And I think the other thing is that, and I think this is closely related to your question, is you talked about the difficulty of fitting in pro bono service in very time-demanding practice. One of the values, I think, of clinic is that it is a law student's first opportunity to practice the art of balancing your sort of predominant responsibilities with public service. And one of the things I say to law students frequently when they say, well, and I encourage them to do clinic, and they say, well, I don't know if I have time to do that because I have all my studies, I say, if you cannot manage to work public service into a law student schedule, you will never be able to work it into the schedule of a practicing lawyer. So one of the great values, I think, of clinic is to learn that balancing.
Michelle in the back.
My name is Sean. I'm a first-year law student, and one of my concerns with myself sometimes and fellow students in my class is this increasing divorce between public interest and working at a firm. And one of the most interesting things about this panel is the idea of not focusing on what you're doing, but who you're becoming. And I'll just a question for Professor Glass would be, in the classrooms when we're focusing on material and learning goals that could be suspicious for students, how do you see a classroom environment, I guess, incorporating some of the successes of the clinical program where the focus is on the work you're doing, but also who you're interacting with and things like that. In the classroom, especially, there are times I feel that we're just completely separated from the cases we're reading, and sometimes because it's English law, 1858, or wherever, and other times because we don't get one out of us enough how this relate in society today to people, that we might encounter in our practice.
So I take it not so much as a question as an ongoing challenge. I mean, I think you're absolutely right that keeping it real in the classroom in all kinds of ways, but that's certainly one way, is important. It's easy not to do it, especially when you're dealing with foxes and such. But I don't do that. I don't do foxes. But I think that there are a couple things classroom teachers can do in the classroom. I mean, there's also this question of how you can influence how choices law schools are making outside the classroom, and how students are thinking about career options and that sort of thing. But in the classroom, I suppose there are a couple things I'd identify. One is the one that you've really already identified, which is trying to keep an eye to context and how things play out. I clerked for a judge who was all about context, and he was sort of famous for, during arguments, when the fancy lawyers who only did appellate arguments stood up and started talking about fancy legal principles, all very pertinent to the case, he would say something like, well, how many people are even in that such and such setting or whatever? Something that clearly, cast a sort of a different perspective on everything that was being considered. And often the lawyer didn't know. That was sort of a little lesson that the facts always matter. But I think reminding students in reading cases that there's, it's all about, it grew out of some real life situation is important to do. It's easy not to lose track of it. I suppose the other way is just trying to maintain in the classroom. I think this is something that we care a lot about here, is trying to maintain a sense that there is that everybody's views in the classroom are worthy of respect, and that those who bring in concerns that are the kinds of concerns that you identified shouldn't be derided because they have not been cleanly presented as a sharp legal argument. The challenge there, and the classic way this comes up, I mean, I don't even know how much this happens in other law schools. At the in Chicago, there's always this question of what you do with fairness arguments, you know. And the challenge, it's like, right, I look fondly back at my Yale past where that was not as much of a struggle. But in the classroom here, I think the challenge is to neither cut off that kind of that part of the conversation, nor let it stop there, really, because one way or another, those are essentially the same, right? The idea of if we have a fancy argument that is grounded on whatever, transaction costs and the like, on the one hand, and then just the word fairness on the other hand, it's not a robust discussion that's going to get us anywhere, and the real challenge as a teacher is to try to pull out what a student means by something like, well, you know, that just doesn't seem fair. It's hard. I think it's hard. I think it's a teaching challenge to not just let that part wither. It's like, okay, yeah, well, okay, fine, and then sort of moving on to the parts that are just easier to bandy about with words.
If I could just pick up on that, you know, great teachers, and this law school has been blessed with many great teachers, do what it is that you're asking them to do. I think back to Norval Morris. And Norval Morris, I will never forget when he introduces the case of In re Gault about due process rights of juveniles. The first words out of his mouth were, how is it that little Billy Gault finds himself in the Supreme Court of the United States? You know, so I do think that can happen and does happen.
Okay, so, yes, final question.
I don't know if the question is much as just an addition. You've given several, I think, excellent values that lawyers learn in clinics. I would add a couple more. One is something that's sort of dear to the heart of Wisconsin, which is context systems. That is, you can't really be a criminal lawyer, an effective criminal lawyer, I don't think, unless you understand in some degree of detail how the correctional system works. What's going to happen to somebody when they go to prison? What level of security are they going to get? What kind of treatment programs are or are not going to be available to them? What's going to happen to them when they get out? And, you know, our clinic, we started with the idea that law schools graduate people with good analytical skills, they've got good brains, but their judgment is impaired because they really don't get the big picture. And, you know, years of practice can do that too, but clinics would seem to indicate that this is something that we're uniquely situated to act with. And again, in the same context, a slightly different angle is that, you know, I guess my view is that we're not necessarily creating a bunch of successful criminal lawyers. We're creating citizens and people who are going to be of consequence in their communities, whether they know it while they're in law school or not. And they really need to know how systems operate and what happens to the poor people who are enmeshed in them. And I think, again, clinics are very well situated to provide that as a value added to their legal education.
So, in wrapping up, I think we've been talking about creating, developing, becoming the ideal lawyer, and this morning we heard the comment about a lawyer being defined as an institutional engineer. We talked about analytical reasoning, lawyers as revolutionaries or not, lawyers as problem solvers. My favorite quote is from Charles Hamilton Houston, who says a lawyer is either a social engineer or a parasite. Now that's probably a little too harsh, but it kind of captures to me the definition of an ideal lawyer. This afternoon we heard a little bit about not enough back padding. So this afternoon we're going to have cheerleading and back padding about the clinical legal education process here at Mandel. So we can adjourn now for lunch in the Green Lounge. Let's give our panel a big hand.